The old illustration said, A in India instigates B, a foreigner in Goa, to commit a murder in Goa. A is guilty of abetting murder. The old 108A abetment from outside India treated Goa as not a part of India. Now this was 1860, the penal code. But from 1860 till these new laws came in, the illustration to 108A reflected that Goa was not a part of India, part of the Portuguese empire, colonial empire, and the 61 liberation of Goa from Portugal was not taken into account all these years and continued to remain on the statute book. That's the break from the colonial, that's the kind of break from the colonial past. One is sedition, which was meant for the colonials to repress its subjects. B, to recognize realities that are part of India, that are part of what was not India under Portuguese occupation and which should have been remedied much earlier, is now a part of India. So, the new section now reads, is section 48 now. A in India instigates B, sorry, it's 47 now. A in India instigates B, a foreigner, in country X now. So Goa is gone. To commit a murder in that country, A is guilty of abetting murder. Then, for 62 years, therefore, the Indian Penal Code contained this. They had not changed this because 1961 was when Goa got independence. Now, another colonial legacy consigned to the dustbins of history is section 48. 47 is abetting murder in India or abroad. Now, this says abetment outside India for an offence in India. Now, the illustration to section 48 makes it clear why acts prescribed as an offence by section 48 did not find favour with the British. If a section corresponding to section 48 in the Sanhita existed in the IPC, a British native instigating someone to commit a murder in India would be liable for punishment in India for abetting murder. This effect was unacceptable to the colonial government. Now, section 48 of the Sanhita makes a person outside India liable to be tried and punished in India for abetting offences in India. Most significantly, the illustration to 48 would permit the Indian government to try and punish masterminds behind terrorist offences in India. The aim of 48 is to facilitate the trial and punishment of several terrorist groups. Hafiz Said, Sajid Mir of the Lashkar-e-Taiba and Panoon of the separatist Khalistan movement are all now liable to be extradited and tried in India. In pursuance of this trend of the security of the state, crime and terror have been strongly punished. Now, organized crime had become a rampant evil in this country. Maharashtra, for instance, and some other states had enacted MAHESH, the Maharashtra Prevention of Crime Control Act. Now, MAHESH provisions have been brought in all India. Under 111, organized crime is an offence under the new Sanhita, unlike in the old penal code, and the provisions of the MAHESH have roughly been reproduced in the new Bharatiya Sanhita. So also, under 113, the Sanhita defines and punishes terrorist acts. Now, the Unlawful Activities Act exists, but the Sanhita also has a provision for terrorist act. It defines terrorist acts in almost the same terms as the UAPA does. So one of the criticisms which is often voiced is, what do you do? Why are there two statutes and how do you distinguish the two? Where does one apply and the other cease to apply? Answer is, if the terrorist crime or the unlawful activity is localized, then it will be the superintendent of police in the given state